the title page.
Yeah, don't know why the thing is not moving. Abraham, come please. Doesn't move it now.
Go to the first page, which will have your title page.
Before I was using this button to move it page by page. Okay.
Okay.
Yes.
Is somebody in the next office close in the other office? Can the person tone it down, because I can hear and everybody will hear what they're saying.
I'll do that now. Savannah, please, your voice is entering more.
Good afternoon, Dr. Oche. Thank you once again for being with us today.
Good afternoon. Good to see you again.
Thank you very much for that very intriguing and engaging conversation of yesterday. We're grateful to you for sharing your experience with us and breaking down that somewhat simple but very technical subject. Thank you very much for that. You made it look very simple, but indeed, it is not as simple as it looks. It is indeed very technical. So on that note, I would like to welcome everyone to today's session. It's the fourth in the series, and we are truly looking forward to this. And so I want to say welcome to the early birds. And I think I will speak with the MBA ICLE. Perhaps we should have some kind of gift for the early birds and consistently do this over a period of time just to encourage the early birds. But having said that, I think we'll just give it a couple of more minutes maybe 2 or 3 more minutes. Let's say it is now 2 minutes past 1. If we just give it another 8 minutes to allow people to log in, we know that the networks can be a bit of a challenge, and then everyone trying to log at the same time, there might be some kind of technical hitches here and there. So we'll just give that grace period of 10 minutes. So we start exactly at 10 minutes past 2, just to give everybody enough time to join in, and so we're not missing out on a lot of what's happening here. Thank you very much, and we'll just wait for 10 minutes past 2. And just to say, while we're at it, a big thank you to the backroom staff, Sarah, her team. Thank you very much for the work you do and for always ensuring that we have little or no technical hitches. I mean, you do a thankless job, and but just to make the point to say thank you. It's very easy to forget the backroom office that make all this possible. But we appreciate you for all the work you do, and thank you very much, Sarah and team. So while we are waiting, I also need to make the point also that all the materials for the 5 days of training will be sent out, and also that the recordings of the various sessions will be available on YouTube. I'm not certain when exactly, but it will be communicated, but they will be available on the YouTube channel. And if you struggle to also join in, and if you're thrown out otherwise, you can also try and join via YouTube. The link for that will be shared at some point during the course of this training as well, so others can join in and we can share with our various networks and platforms so people can join in via a YouTube channel. And also, if you have questions, please drop your questions in the Q&A. For comments and general greetings, you can drop that in the chat box. But for questions, just drop them in the Q&A. It's easier for us to navigate the questions, but if you end up dropping your questions in the chat room, as always, there are a lot of messages in there, and it might just be lost in the deluge of messages in the chat box. So would appreciate if you can drop your questions in the Q&A session. In the Q&A chat room, which is just beside the chat room. So there's a Q&A icon there. You see a Q&A icon just beside the chat icon. So you can drop your questions there. So while the clock ticks down to our agreed 10-minute hiatus before we start, I'd just like to point out some facts that this training has, in a way, created some kind of inclusive platform for a lot of people to interact and to meet each other. I noticed the mix of lawyers from various branches, from as far as Kano to Umahia, and it's refreshing to see that it's actually very pan-Nigeria. What this training, this MBA ICLE initiative has thrown up, and I think it's something that MBA needs to think deeply about and to find a way to sustain going forward. It's been very, very interesting seeing the diverse mix of people, and that's brought various perspectives to the kind of questions that we have seen in the course of this 4 days thus far. Last year, I thought was very interesting, the first series of the employment law series, but this year, I would say without fear that it has trumped that of last year in terms of the diversity of attendees, delegates, the numbers, as well as the kind of questions that have been asked. It shows that there's actually been a deliberate leap in terms of knowledge acquisition based on the depth of questions that have been asked this period. And I think it's a good thing, and the MBA ICLE would need to build on this. So gentlemen and ladies, thank you very much. It's now 10 minutes past 2, sorry, and we will be starting. Before I introduce our facilitator for today and the topic for today, I'd like to introduce myself, standing in for here on behalf of the MBA ICLE. My name is Ose Okbeku, and I will be moderating the first part of today's training, which will be the presentation. The presentation today will be presented, the presentation of the facilitator today will be the person of Okechukwu Umemo. Okechukwu Umemo is a consummate dispute resolution lawyer with special focus on bias for labor and employment law. He's also an arbitrator and the graduate of University of Uyo. He also holds a master's degree from University of Ife, and he's currently pursuing his doctorate as well. Okechukwu Umemo is a fellow of the Chartered Institute of Arbitrators, UK Nigerian branch, and is a consummate, very, very consummate litigator and arbitrator who is also a notary public. He's a partner in the law firm of the Lawcrest LLP, and also heads the dispute resolution practice of the firm. Okechukwu has practiced in all the cadres of the courts in Nigeria, but extensive experience in the appellate aspect of litigation. And so he's in a great position to lecture us today on the unintended consequences of some of the provisions of the Constitution and the rules of the NIC when it relates to appeals. We're talking about the civil procedure rules of National Industrial Code of 2017 and the others therein. So without much ado, I would like to introduce Mr. Okechukwu Umemo and ask him to come on and delve into this topic, just as a way of setting the tone for this topic. For a very long time, there was this ongoing argument as to whether, when it comes to employment and industrial relation issues or labor matters, whether the National Industrial Court was the final court. There was very strenuous arguments, and on a couple of occasions, we've had opportunity then, the Employment and Industrial Relations Committee of the Section on Business Law, to engage with the then head of National Industrial Court Lagos, who is coincidentally now is the president of National Industrial Court, Justice Kanye, on these vast issues. And he was of the view that litigation must come to an end at some point. And because of the very personal nature of some of the employment-related issues, it was important that it ended at the National Industrial Court so that if the employee actually won, they could enjoy the benefits of the judgment. I mean, sound argument from him, but we are of the view that there has to be the constitution that created appeal was his very wisdom realized that the National Industrial Court, being the final court, might make errors of judgment. And so we had to test those decisions at the Court of Appeal. So there has to be a way of testing those cases. And then that conversation went on until the groundbreaking decision of the Supreme Court in Iwu and Skybank. And that totally changed the concept of appeals. That in its own way has also created another problem. But to break it down also, it doesn't mean that even before then there was no right of appeal, but it was differentiated in the sense that for fundamental rights, there was no need for leave of appeal, right? But for other matters, you now means that you have to get a leave of Court of Appeal to appeal. This created a lot of practical issues, and without letting the cat out of the bag, I would like Mr. Okeomemo, Notary Public Partner and Esquire, to now delve into these very contentious issues. And again, I would say some unintended consequences of our rules and legislation. And more importantly, to delve into this, the procedural issues and challenges that this has brought upon employers and employees, litigation respondents, and everybody in this value chain of employment law jurisprudence. Mr. Memo, on this note, I would like to welcome you, and please, you have the floor.
Thank you so much, Joseph, for not just the introduction, but the way you prepped what we have to expect in terms of when we dive into this matter. I thank the ICLE and other panelists who have made this very possible. I particularly was asked to speak on the topic, leave to appeal decisions of the NICN and stay of execution, reconciling Order 64, Rules 8 and 13 of the NIC Rules 2017, and Section 243, Sub 1 to 3 of the Constitution of the Federal Republic of Nigeria. In looking at those issues and looking at what actually practitioners face every day, I come to the conclusion that all that I needed to talk about is how do we deal with the hurdles we encounter in state of execution and state of proceedings when dealing with decisions of the National Industrial Court, particularly in view of the provisions of Order 64 of the rules of that court. What I will try to do is like what has done at this onset. I'm not going to try to lecture per se. I will just speak to what the issues are. I will share my personal experiences from the National Industrial Court and allow us to appreciate the two contending aspects of the issue at hand. One is the right of a judgment debtor, that constitutional right to pursue an appeal, and the other is the right of the successful party to reap the fruits of his judgment. So we look at it in proceeding. I'm going to deal with introduction. I will talk about what I understand the Order 64, Rules 8 to 14 to set out to achieve, what the draftman's intentions are, but how the court has interpreted and applied them. I will also look at those few instances where the National Industrial Court has actually granted stay without insisting on the strict compliance with the provisions of Order 64 of the rules of the court. Then we'll conclude, and then we'll be able to take questions from and discussion from other panelists. So essentially, the National Industrial Court Civil Procedure Rule 2017, which is applicable to all proceedings, all civil proceedings at the National Industrial Court, amongst other things, make provisions which some persons have considered to be onerous it depends on what side of the bargain a lawyer finds himself. There's this popular saying that the lawyer has two hands. The first time I heard it, I was asking, is there any other person who doesn't have two hands, except the person has some kind of disability? So the person who used that expression for the first time to my hearing explained to me what it means for a lawyer to have two hands. Today, a lawyer is a judgment creditor. He will extol and praise the provisions of the 64 and how it makes enforcement of judgment so easy, so as the judgment creditor will be able to reap the fruits of his judgment without being stretched for years on appeal, so to speak. And then the next day, the same lawyer is the judgment debtor, and will find reasons to criticize this same order and why it ought not to be allowed to stand. As we speak, we not have a situation where the appellate courts have been able to say, oh, some of these decisions, some of these provisions are onerous. So as we speak today, in most part, they do apply and they control what happens post-judgment, or in other situations where stay of proceedings is an issue. When I speak about stay of execution as we proceed, I will essentially be talking about principles which also apply to stay of proceedings, since from the rules we are reviewing, similar requirements apply to both of them. So why there are the notion that why Order 64, particularly rules 8 and 13, has given an applicant, a judgment debtor, room to apply for stay of execution. There are those who also believe that why the rules of the court gives with one hand, it takes away with the other hand, because the conditions are so difficult to meet in most of the cases. Why do we have this situation where we have difficulty in meeting the requirements for stay of execution of proceedings at the National Industrial Court? It is very simple. Just like we had mentioned already at the introduction, with the decision in Iwu and Skybank in 2017, we got clarity as to what happens with regard to appeals coming from decisions of National Industrial Court to Court of Appeal. While interpreting section 243 sub 3 of the Constitution, the Supreme Court came to the conclusion that there is a right of appeal. In fact, it frowned at the notion that a trial court could also be a court of last resort. So while recognizing that right of appeal, the Supreme Court further made it clear that except for decisions arising from Chapter 4 of the Constitution, that is on fundamental human rights, that every other decision of the National Industrial Court must be with the leave of the Court of Appeal, as provided by section 243 sub 3 of the Constitution. So with the Court of Appeal as the court of last resort, of course. So now this is what raises the issue, the challenge, the conundrum we are trying to resolve, that while we as practitioners are very conversant with the length of time and what it takes to actually file an application for leave at the Court of Appeal and to obtain leave, we understand that for you to be able to do this, on the average, it might take up to 3 years. For jurisdictions that are divisions of the Court of Appeal that are very busy, like Lagos, for instance, it might take longer period in some certain instances. But 3 years is a fair average for you to be able to obtain leave of the Court of Appeal to appeal the decision of the National Industrial Court. And unlike in most other trial courts, as you will notice, where leave to appeal will actually start from the trial court, in this case, it is only the Court of Appeal that the Constitution has given that jurisdiction to grant leave to appeal. So now, why we have established that, yes, these decisions are appealable, we now have the issue where your constitutional right of appeal has been established. You can actually test decisions of the National Industrial Court at the Court of Appeal. But for you to do that, you have to first apply for leave, obtain the leave of court, then file a notice of appeal, compile and transmit record. In other words, make sure that the appeal has been entered, then you proceed with your brief of argument and other appellate processes. Now, the clear provisions of Order 64, Rules 8 and 13 is that for you to be able to move the court to exercise its discretion at all in your favor as a judgment debtor applicant asking for stay of execution, that you must have complied with all the provisions of those rules, which include, amongst other things, that you must have compiled and transmitted record. In fact, so as not to leave any ambiguity, the rules, after talking about transmission of records, said the appeal must not only be entered, but you must have obtained an appeal number. Now, it creates that problem in the sense that when you have that judgment against you at the National Industrial Court, you have filed your motion for leave to appeal. Instead of the National Industrial Court to consider what the Supreme Court, in a long line of cases, have established to be the basic principles for stay of execution, which mostly is the nature of the subject matter in dispute, whether maintaining status quo until the final determination of the appeal will meet the justice of the case, the chances of the applicant being able to enjoy the benefits of a federal judgment on appeal, and where the judgment in respect of money and cost, whether there is a reasonable probability of recovering this back from the respondent if the appeal succeeds, and whether the satisfaction of the judgment will affect the judgment debtor's ability to prosecute his appeal. Essentially, the position of the law from the Supreme Court over time is that a court should not ordinarily interfere with the judgment creditor's right to enjoy the fruits of his appeal. Courts should not make it a habit to deprive a successful party of the fruits of his judgment. So they will always look for exceptional circumstances to grant such self-execution. And in other cases where the appellant is able to file the notice of appeal, compile and transmit record, it will move the matter out of the trial court's jurisdiction for the purpose of enforcement of the judgment, and the appellate court will now become seized of this matter. But that is essentially what Order 64, Rules 8 to 14 set out to change when it comes to decisions of the National Industrial Court. So why the appellant, the judgment debtor, is at the Court of Appeal trying to get this leave to appeal at all, his motion for stay of execution will come up for hearing at the National Industrial Court. The position of the National Industrial Court, as I will show with most of the cases I will review, including the ones I was personally involved in, will show that the National Industrial Court will at that point inform the applicant that you have not complied with the stipulations laid down by the rules of the court, which amongst others include you must have filed a notice of appeal, pay for the compilation of the records of proceedings, exhibit a CTC of the judgment or the order the party is appealing against, exhibit evidence that the appeal has been entered at the Court of Appeal, and show that there is a valid appeal before the Court of Appeal. Exhibit evidence that leave has been granted by the Court of Appeal. So when you deal with all of this, you discover that in most cases, it is unlikely that the person who is trying to test the decision of the National Industrial Court would have been able to comply with this requirement before his application for stay of execution become right for hearing. So what it means essentially, some have interpreted it to mean essentially is that that desire for the National Industrial Court from the onset not to be subject to appeal has somewhat fine expression in the provision of the 64 of the rules of the National Industrial Court in trying to discourage you by all means possible from pursuing an appeal. And if you consider the nature of money judgments, when the amount is substantial, most of the time from experience, you know that the payment of the sum inside an interest yielding account in the name of the court will somewhat affect the desire to pursue the appeal. So amongst other things, to make it clear what the provisions of the order set out to say, you see that both order 64-81 and 2 make it clear, one, that the filing of a stay of application motion does not serve as a stay. We know that in practice, it does, because a court will not close its eyes to a pending motion for stay of execution and go ahead to enforce that judgment. The court will ordinarily, usually, dispense with that application before proceeding with enforcement. And I'm happy to say that from my own experience, despite the provision of Order 64-81, that the National Industrial Court will always dispense with that motion, even though the rules say it does not serve as a stay and ought not to stop the enforcement of the judgment. But usually, they will dispense with that motion before proceeding with enforcement of the decision. Then, sub-rule 2 makes it clear that even an appeal, just like section 47 of the National Industrial Court Act, that an appeal itself does not serve as a stay of execution. So what happens now, in essence, with these provisions of the National Industrial Court rules is that judgment debtors and counsel acting for them find it onerous, find it somewhat against the interest of the losing party who needs to test the judgment on appeal. However, it is easy to understand that the main reason for those stringent positions is the very special nature of the National Industrial Court and the fact that it caters mostly for employees who oftentimes are claiming for retirement and other benefits, unpaid salaries, reinstatement, damages for wrongful termination or dismissal, and so on. So this class of people certainly do not have the luxury of time. Imagine, for example, a man who worked for 60 years and upon retirement, his retirement benefits have not been paid. He will not have 10 years to wait while the Court of Appeal decide whether or not he should get his terminal benefits. So there is the philosophy behind some of these provisions to ensure that the vulnerable persons who sometimes are claimants before the National Industrial Court are not further subjected to the usual rigmarole that is associated with the appeal and stay of execution, which may deprive a successful party of the fruits of his judgment for many years, or the shenanigans of judgment debtors and their counsel, who even sometimes do not intend to diligently pursue an appeal, but yet will file a notice of appeal and a motion for stay, then go to sleep, while the judgment creditor continue to suffer without getting the fruits of the judgment. So while we recognize this essential, special nature of the National Industrial Courts and the persons we mostly cater for, we are still of the view that it ought to be balanced with the right, constitutional right of a judgment debtor to pursue an appeal, and that the NICN should go beyond the letters of Order 64 of the rules and look at those cases where it is important that a must, as a matter of law, consider those silent exceptional circumstances that will warrant a stay of execution, and to, in deserving cases, grant such a stay because it will serve the overall interest of justice. So, while we have considered the provisions and the way and manner it affects both parties, both the judgment debtor and the judgment creditor, and how it can be favorable to the judgment creditor, and the circumstances where the court ought to also consider other conditions for stay as have been established over time by the appellate courts, we now want to consider how the National Industrial Court have applied these decisions in few cases. Having in mind that we are looking at the fact that the judgment debtor applicant who want to challenge an appeal do not have control about what happens at the Court of Appeal and the length of time it takes to get leave granted. And the fact that despite that, the National Industrial Court in most cases have insisted that these conditions must be met. In one of the cases I'm going to review where I was counsel, Justice Essien held and stated clearly that by the clear provisions of the rules of the National Industrial Court, the National Industrial Court does not recognize a situation where a motion for stay will be predicated on a motion seeking leave to appeal, which in most cases is what a judgment debtor have to, by operation of law, file first when a judgment is given against him. The court said it does not recognize that a motion for stay could be predicated on application for leave to appeal. You must have filed a valid notice of appeal as a starting point. So what happens in essence is what I'm going to review with two cases. I've deliberately, even more than two, but let me start with these two where I was personally involved. I could speak more to the facts. In just June of 2023, Honorable Justice Oji, PhD, delivered a ruling in Ms. Lyndon Majuro and the COCOP in suit number NICN LA92M of 2022. Now, in that case, the court stated clearly that where an appeal has been filed and all proceedings transmitted and appeal entered, which was not the case in the instant case the court was standing, that the court must stay execution on the condition that the judgment sum must be paid into an interest-yielding account in the name of the registrar of the court. The court was given an interpretation to Order 64 Rule 8 sub 3. What Order 64 Rule 8 sub 3 provides essentially, if you read it carefully, is that apart from filing a notice of appeal, compiling and transmitting record, obtaining an appeal number, when all this has been done, that the judge of Natural Industrial Court still has a discretion whether or not to grant stay. And in the case of money judgment, where it decides to grant stay, it must be on the condition that the judgment sum be deposited into court. The use of may by my lord in that decision is instructive. It is a clear interpretation of that 64 Rule 8 sub 3, which apart from setting these onerous conditions, insist that the court have a discretion whether or not to grant a stay, and where it does choose to grant stay in a money judgment, that sum must be deposited into court as a condition precedent for such a stay. So the question now arises, does this mean that the NICN has a discretion to stay or not to stay execution even after transmission of the records of appeal and the issuance of an appeal number? Will this not amount to sharing jurisdiction with the Court of Appeal and negate the long-established principle of law that the moment an appeal is entered, the lower court has no jurisdiction to deal with the matter anymore, and that the appellate court must now be consist of the matter? Indeed, what counsel would do often before now to show that counsel and the judgment debtor is desirous of pursuing an appeal diligently is to, as quickly as possible, compile and transmit record and file other appellate processes that needs to be filed, including the appellant's brief of argument at the Court of Appeal. I've had occasions where by the time the motion for stay of execution will come up before the trial court, the appeal has been entered. In some cases, the appellant's brief filed, and you notice that the trial court will not assume jurisdiction. But the practice is to go to Court of Appeal and file the same application for stay and continue with the proceedings at that level. But that is not the intention of the draftman in Order 64 of the NIC rules. So it raises issues that only Court of Appeal could determine in due time. Then what does lawyers in practice do in trying to avoid these provisions of the 64, particularly when they are acting for the judgment debtor? The EcoCorp case I cited earlier, what the council did, and I've seen other cases where it has been done, is to file the motion for stay at the Court of Appeal. Upon filing the application for leave to appeal, file a motion for stay at the Court of Appeal, and argue that there's a pending motion for stay at the Court of Appeal, and until the Court of Appeal dispenses with that motion, no further steps should be taken. So what happened in the EcoCorp case is that we filed a motion to garnish the accounts of the judgment debtor, and another NICN was made. Upon the motion for counsel to the judgment debtor coming up, asking the court to take no further proceedings and set aside the garnishing proceedings until the motion for stay at the Court of Appeal was heard and determined, we argued that that motion ought to be filed at the trial court as a matter of as a matter of law, and that even at that, all the conditions laid out in Order 64, Rules 8 and 13 must be fulfilled. Counsel argued, and intelligently too, that it is for the Court of Appeal before whom these appellate processes were pending to determine whether or not they are valid or not. However, the National Industrial Court in that instance rejected that argument and proceeded with enforcement of the judgment, dismissed the motion for stay, and enforced that judgment. Now, like I mentioned earlier, a lawyer has two hands. I was very happy with that decision. I didn't see anything wrong with the provisions of the 64, Rules 8 and 13. On the contrary, in Lillian Akoma First Bank, which was decided by Justice IJSN, PhD, I was on the other side of the equation. As lead counsel, having filed a motion challenging the decision of the court on the basis that the action was caught by limitation. Upon dismissing that motion on the ground that limitation does not apply to contracts of employment, relying on the Supreme Court decision in Johnson, we disagreed with the court and we went on appeal. However, we filed for a motion for stay of proceedings, and Justice Lesson rejected and refused that motion for stay of proceedings on the reasoning that a stay of execution of proceedings pending appeal and determination of a motion for, let me take it again, on the reasoning that when you file a motion for stay of execution, it must be predicated on a valid notice of appeal filed at the Court of Appeal, that it was a strange procedure to ask the National Industrial Court to stay proceedings while all you have at the Court of Appeal is a motion seeking leave to appeal and not a notice of appeal itself. The argument that a motion for leave to appeal is an appeal did not sway the court at all, and the court therefore refused the motion for stay of proceedings. And I'll use this case as an example. Why that motion for stay of proceedings for leave to appeal was still pending at the Court of Appeal, trial commenced in the matter. And this is what will happen most of the time if you are in a situation where you are trying to stay proceedings. The National Industrial Court, kudos to them, have shown that they could determine matters faster than other trial courts or most of the other trial courts. So it is most unlikely that while you are trying to, it is most likely that when you are trying to get leave to appeal, the case itself will be determined by the court. So I also want to talk about few instances where the National Industrial Court have not applied the strict provisions of the 64, but instead rely on the old principles of law to see whether there are circumstances that will warrant the grant of stay. One of such cases is Union Bank of Nigeria against Amanze, suit number NICN LS 72M of 2021, which was determined on 2022, February of 2022. In that case, you will see clearly that even though there was a notice of appeal filed, but records have not been compiled and transmitted. Yet, despite that, the court was of the view that Justice Danjiba was of the view that stay could be granted on the condition that the judgment sum be paid into court, and stay was thus granted. Our other case is Patrick Ekpe against FCT Microfinance Bank Limited, which was decided in July of 2021 by Justice Abakwaba. This case is more interesting because in this case, what was filed was only a motion for leave to appeal at the Court of Appeal. No notice of appeal has been filed, record has not been compiled and transmitted. None of the steps listed in Order 64 have been met. But despite these conditions, my lord, in that case, relied more on Section 747 of the National Industrial Code Act and gave the interpretation that that act gives a condition that the court could grant a stay, conditionally or unconditionally, or on the basis of the condition listed in Order 64. That's the first time I've seen that interpretation given to that section of the Act. And by using that interpretation, the court ordered a stay, even though no notice of appeal has been filed. Contrary to the decisions we have made reference to, including Akoma and First Bank, where your state said that motion for leave to appeal can never be a basis for an application for stay at the National Industrial Court, because that's what the rule says. But in this last case, the FCT microfinance case, Abakwaba agreed that because of the nature of the matter, it will serve the interest of justice for the money to be paid into an interest-yielding account, and stay was granted on that condition. So what is obvious is that in those cases where the court have granted stay by NIC, it has been conditional, and there have been mostly monetary judgments, where the court will now extract the price from the judgment debtor of paying the money into an interest-yielding account before proceeding on appeal. So in conclusion, it is safe to conclude that unless you have met the conditions, filing notice of appeal and compiling and transmitting record and obtaining an appeal number, it is most likely that the court will not exercise discretion in your favor. And where you have done all these things, the court will now look at the case and see whether it is one that deserves a stay. And where it is money judgment, it will only grant that stay on the condition that the money be paid into an interest-yielding account. So on those rare occasions where it had deviated from this, what is obvious is that a price was still extracted, which is payment of the judgment sum into an interest-yielding account. The courts in those cases have not established any special or different conditions that justify that deviation. In all, until we have an opportunity of testing these provisions further at the Court of Appeal, this is what the state of the law appears to be now. Thank you very much, and thank you for listening.
Thank you very much, Okechukwu Memo, for that very succinct and illuminating presentation on the challenges with respect to the rules of National Industrial Court when it comes to appeals of decisions of National Industrial Court. I mean, at least we're grateful that, for one, there can be appeals against decision of National Industrial Court and not the final court, as it was being presumed and being backed around for a very long time. To that, we have, I mean, every litigant, like you said, wearing two hands, has two hands, does have an option to appeal if they so wish. But managing the appeal process, as well as the stay, is now where we seem to have a conundrum. And I would, at that point, welcome Leonard Silk in our Wilson to also share some experiences with us. If Leonard Silk is able to unmute himself and say one or two things on the topic before we go into the Q&A proper. Silk, are you able to chime in on this? Okay, if Silk is not able to say something now, Dr. Uche, you are with us here. Do you have anything to share with us on this point before we go into the Q&A?
All right, thank you very much. And let me begin by congratulating our colleague, okay, for the way he has presented the topic clearly and without any ambiguity as to the current state of the law in respect of the subject matter. So, okay, thank you so much. Clear understanding has come out from your presentation. Barrister said, let me just give you a little background to what we now have as the National Industrial Court. You recall that the Trade Disputes Act, in fact, when it came by way of Decree number 7 of 1976, the current Trade Disputes Act, the National Industrial Court was actually part of that Trade Disputes Decree. Now, following a series of cases, even within that period, that will even go to the normal state high court, federal high court, on the issue of jurisdiction. An attempt was made by the then military government in order to elevate the National Industrial Court to give it some exclusive jurisdiction over employment matter through a particular decree called Decree number 47 of 1992. The idea at that time was because quite a number of cases that were going to, especially state high courts, employment-related cases, those courts were given not just contradictory decisions, but sometimes decisions that a specialized court like industrial court would not have given. I recall one when, during the crisis in the banking sector, within the union, a faction of Nubife went to a state high court, and because at that time the Minister of Labor, Bunu Sheriff Musa, had advised that in order to settle that matter, one of the arrowheads should be promoted so that technically he will be out of the union. Do you know that a state high court now granted an injunction to the fact that an employee should neither be promoted, should neither be demoted, should not be transferred, or should not be dealt with in any manner at all? And the guy had a copy of that injunction. And therefore, it alarmed the federal government that because an industrial court would not have gone to that extent, that there was need to grant this exclusive jurisdiction. So that was done through Decree number 47 of 1992. Now, with that, it was presumed that, yes, we now have a court where all these kind of matters relating to employment will go to. Yeah, but again, following other cases, it was not mentioned in the Constitution. I mean, that was the beginning of what today we have seen, Section 254 and all those. But my view here, ladies and gentlemen, and I totally agree with what Oke has said, is that in not trying to create a very strong industrial court that will be stronger than what we had under the Trade Disputes Act, which the decree number 47 of 1992 tried to reinforce very unsuccessfully. My suspicion is that the third alteration went too far, to the extent that it appears that it created another Supreme Court. In fact, at the time it mentioned that certain matters could never be appealed. I think that was what has alarmed the regular courts, including Court of Appeal and the Supreme Court. So when Justice Mary Odili and other judges in Iwu made that decision, I was not surprised. And therefore, I think the real battle, fundamental battle here, is that both the Court of Appeal and the Supreme Court, they are very wary of some of the powers that had been given to the National Industrial Court. And we are going to continuously see a situation where through interpretation, narrow interpretations, they will try to whip the industrial courts into line with all the others. In fact, one of my colleagues once said that what we're likely to find, we will find that industrial courts, contrary to, again, if you look at the history, that the industrial court will soon become like every other high court. And the difference will be that it will be a high court that has jurisdiction to handle, employment-related matters, which will be contrary to the intentions. And like Oke mentioned, the intention of those who drafted all the others he had been mentioning. So I think, in conclusion, that we must see this from the point of view of, in trying to protect and project an industrial court that should be able to deal with a matter relating to employment in a professional manner. I think we have gone too far when we, through legislation, conferred it with kind of power that only the Supreme Court should normally have. And therefore, that will be the battle we'll continue to have. In some other jurisdictions, you find that this kind of matter will not occur, not because the Constitution has given this kind of, the kind of power we have here to the industrial court, but what has happened is that through practice and through jurisprudence, the industrial court has established itself in such a manner that parties are not likely on their own to go outside the industrial court in order to test judgment. Because like when I worked in the industrial court in Kenya, all the parties will tell you that if a decision is made here at this level, whether there is a right of appeal, but they tell you it's waste of time. Because every other court will tell you, wherever you go to, that is the court where that decision should be taken. And therefore, we're not likely, except if it is very outrageous. And that is my view on this matter. Thank you very much.
Thank you, Dr. Uche, for the dive down to history and part of the surrounding information, background information to the evolution of the National Industrial Court. And thank you very much. So that, we have some historical perspective and ideas to how we arrived at where we are with National Industrial Court. Saying that, I would also, based on what you've said and a couple of questions here before I go into the question, just to make the point also that the National Industrial Court is a specialist court. And to the extent that all it deals with is that specific subject matter of labor and employment and anything connected herewith. And so a lot of the judges you have in National Industrial Court are well schooled in labor and employment, HR, or industrial relations, and have practiced in that space or taught in that space as academicians as well, or practice as lawyers in that space. Now, the challenge we also seem to be having, and that will bring me to the first question that I have here for OK, will be that because these lawyers, these jurists are well versed in employment law, international best practices, their decisions are also changed with some of these elements of best practices. And they are more forward thinking, if I may use that word, without sounding as like I am trying to undermine the competencies of the justices in the Court of Appeal. However, majority of the justices in the Court of Appeal are of the common law school who still see employment law from the prism of master-servant relationship, which typically, I would say, is not the most forward-thinking approach to employment and industrial relations. So there will always be what we tend to see now, unlike what you said happens in Kenya, where decisions of National Industrial Court based on international best practices and modern practices in other climes are overturned at the Court of Appeal because the majority of the judges of the Court of Appeal are of the other school. So you could say the left and that of the National Industrial Court are judges on the right. So is there any merit in having a specialized appeal system? Whilst I do not believe that it is prudent for National Industrial Court to be the final court, I think it's actually prudent to have an appeal system. But my thinking is, wouldn't it be more prudent to have a specialized appeal court, also manned by jurists who understand this forward and modern principles that deals with the world of work as it is today, not the world of work as it was in the 80s and in the 90s. Perhaps we would have some congruence in terms of decisions from the National Industrial Court and the Court of Appeal like you have in other climes. And mind you, in most climes, you have an employment appeal tribunal anyway, which listens to the cases from appeals from the employment tribunals. And so that would somewhat lead me to the first question here. Okechukwu says, please, considering the challenges enumerated as per seeking leave of the Court of Appeal to appeal against decisions of National Industrial Court, as we encounter everyday practice, is it not desirable that we start canvassing for an Industrial Court of Appeal as optable in other jurisdictions? I mean, this literally that took that question out of my mouth. Barrister OK Esquire, what are your views on this? And Dr. Uche, I will come back to you on your views on this as well. If you want, I can repeat that question in a nutshell.
I get the question.
Okay, fantastic. So if you can give it a bite. Yeah.
Clearly, it is something I've personally had occasion before to address on whether there is need for a special procedure for this appeal. Say, for instance, the issue we're talking about leave. If even without having a special or different Industrial Court of Appeal, if the rules of the Court of Appeal recognizes that these are special in nature and give it a different consideration as different from that given to other motions for leave to appeal, and in all cases ensure that they are had and determined within a few months, it will help a lot. What people have also suggested, like we mentioned earlier, is to have that special court. And I think it is ideal, it is proper, but knowing where we have, as we speak today, the Court of Appeals are understaffed. We don't have enough justices at the Court of Appeal. And essentially, it will appear as if financing for the courts is a problem. Will we have a situation where the decision makers will now establish a parallel Court of Appeal essentially for labor and industrial relations? It is recommended, but whether it is practicable in the shortest term is what I doubt seriously. The other third option is to ensure that as many deserving judges of the National Industrial Court are promoted to the Court of Appeal, just as we have when you deal with the issues of Sharia law, for example, where justices of the appellate courts who have special knowledge in those courts will have to sit in proceedings relating to issues of Sharia law and such. If we have more of these experienced judges of the National Industrial Court promoted to Court of Appeal and they participate, even if the entire panel is not made up of them, but at least one of them sits in each of such panels so as to help to throw more light, provide explanations and other things to his colleagues as they go along. In recent time, one of such promotions has happened, but I don't think we have enough judges coming from National Industrial Court who get to Court of Appeal so as to try to bring the kind of changes we expect them to bring in view of their specialized knowledge and background.
Thank you very much, okay. Dr. Uche, I mean, we'd like to hear your views on that question as well.
All right, thank you very much. I think that the industrial court actually boxed itself into this problem. Because when you look at the Trade Disputes Act, even when you go back and look at the Trade Disputes Decree, Decree number 7 of 1976, you'll find that the industrial court is actually supposed to be a court of appeal. Because it was not actually to exercise original jurisdiction. At that time, during the time of people like Paul Atilade, it always sat by way of panels, not individual judges. And matters could only come to that court usually through the industrial arbitration panel. Therefore, I think that is where we will need to correct, not really creating another court of appeal, and that will also dovetail into having a Supreme Court, because matters in Nigeria will never end at the Court of Appeal. And therefore, I think what we may need to look at is, should the industrial court be a court of first instance, especially when you have an industrial arbitration panel, or should the industrial arbitration panel be strengthened as you have in other countries, where it is actually called court of arbitration? And matters must start there. For instance, even if you look at the Industrial Court Act, you'll find that, yes, all those matters that involve collective like union must proceed in that manner. And therefore, the jurisdiction of the Industrial Arbitration Panel, which you can call industrial or court of arbitration, matters must go there. And therefore, that the industrial court, as was the original intention, must not be court of first instance. Because I think that's where the problem is. And by so doing, you will achieve what in fact is being planned now. And again, the idea, if you look at the origin or where the industrial court started, the judges were not to sit on individual basis, because that was the intention. So when it started from the promulgation of the National Industrial Court Act, where there are now individual judges, it becomes very, very difficult for decisions at that level not to be appealed against. Because if, as we had during when it was part of the trade dispute mechanism, where you have a judge presiding and you have tripartism in any panel you compose, the judge, and there must be somebody representing the social partners. And where that type of court sitting as appeal, when they take a decision on a matter, it will be fruitless to attempt to appeal further beyond that level. Yeah, because everything will have been taken into account. More so when you look at those who have examined that matter. Many times I still go back to look at the judgments made in those days, where you find a man like Justice Paul Atilade, you find that part of the judges, a former president, general secretary of NLC. You find somebody who had been like a HR director, 3, and they sit over a matter that came from industrial arbitration panel, and they make a decision. It will be very difficult, even if that matter were to proceed beyond that level. But in the current situation, to recommend that a specialized court of appeal be established, and then they will order also be clamor that another Supreme Court, that would be a bit difficult in my view. Rather, I think that the industrial court must look at whether they must continue to be a court of first instance, and they must go beyond that to see to what extent, in terms of sitting alone of the judges, whether that will serve them, especially into the future. But I think the court should not be a court of first instance. That's my view.
Thank you. Thank you, Dr. Uche. And I mean, let me just, a bit of another view today says, as it stands now, the National Industrial Court is also a court of first instance in some cases and not a court of first instance. So when it comes to trade disputes, which is dispute between trade unions and employers, right? It is not a court of first instance, because based on the Trade Dispute Act, it must have to go through the process of mediation, conciliation, arbitration before it gets to National Industrial Court. At that point, National Industrial Court is a court of first, is a court of appeal. It's not a court of first instance. The only time National Industrial Court is a court of first instance, and I understand that absolutely, is because for non-trade disputes, so between employer and employees, the process of not having to go through mediation, conciliation, and arbitration before getting to National Industrial Court is a bit long-winded, so much so that that could actually take 15, 20 years. So if an employee has a claim of 2,000 naira or 2 million naira in 2020 and had to go through that process of conciliation and arbitration and mediation at the Ministry of Labor before getting to the arbitration, and then after that appeal, except the minister arrests it in between, it might take another 15, 20 years. And then the problem that National Industrial Court was trying to solve, we've ended up going back to that, which is shorten the period it takes for employment-related litigation to actually end, and so that each party, if the employee is successful, they can get the fruits of his litigation. And so for me, I would think that if that was this reason for setting up National Industrial Court, going back to making every other kind of dispute pass through that process of mediation, conciliation, and arbitration before coming to National Industrial Court might truly be a disservice and work against the mischief that the creation of National Industrial Court and dividing the kind of costs that can come to it and directly, and what that can go through the arbitration, the dispute resolution mechanism set out in the Trade Dispute Act, it really defeat that mischief, which is to make sure that these things are done on time and that people can get benefits and real benefits of judgment if in their favor, and that there can be an end to litigation somewhat. And that's my view on that. So
okay, let me just say a few things. Sorry, Barrister Ose. If you look at the Trade Disputes Act, especially the part of it that you have just mentioned, the procedure, beginning from Section 5 for the Trade Disputes Act, you'll find that, with due respect, all the stages involved are timed. In fact, for arbitration, for an award not to be made in 21 days, you will need to get an extension officially
Yep.
And therefore, quite frankly, that process moves very quickly. Of course, I recognize the fact that there may be instances where, but the main issue here is the status of the industrial court, as to whether it should seek a situation where there is a court of appeal established for that purpose, or whether the industrial court itself should rather be the court of appeal on employment matters. That would be my suggestion. That I think that given all the powers it has, it should be a court of appeal.
Thank you, Dr. Uche. We're going to continue on this, but
thank you to us and Dr. Atto. I think the back and forth, both of them have merits. But I think what is practicable now is already being done. I mean, in terms of, I was trying to remember Justice Amadi the last time I was talking. So he has made impact in some decisions he has given at the Court of Appeal since he was moved from the National Industrial Court to Court of Appeal. So what it means is that if a conscious effort is made to promote more judges of National Industrial Court to Court of Appeal, their influence in the long run is going to impact on the issues. And if we take all the matters to, like Dr. suggested, if we take all the matters to the Industrial Arbitration Panel, they will also now suffer the same fate that the National Industrial Court is suffering. Because the National Industrial Court is suffering now that it's a specialized court who would have loved to deal with all the matters relating with employment and end it there without having to go up to Court of Appeal. So at that stage now, we now have the arbitration panel playing that same role, while the National Industrial Court will now play the, I think it will also be overwhelming for that process that it's supposed to be specialized and caters for certain things under the Trade Dispute Act. But all in all, it is for government to create more courts, get more judges available, and finance the courts more so that there will be, these delays we suffer will no longer be the order of the day.
Thank you very much, okay. Okay, so there's another question that deals directly with the topic today. It says, with the filing of unnecessary processes, that is notice of appeal, records of appeal, brief of argument, etc., without obtaining the leave of the Court of Appeal, not amount to an incompetent appeal, given the fact that you cannot put something on nothing and expect it to stand? Okay, this one is directly for you.
Clearly, that is the whole problem we are trying to talk about, that the rules expect you to comply with those requirements. But you can't do that. You cannot do them without having obtained leave first and then come back to final notice of appeal. So the problem we identified today in the small discussion we had is that you must do those things. You can't file a notice of appeal. You can't file a brief of argument. You can't take those steps without having first obtained the leave of court. And that the problem is that while you are trying to obtain that leave of court, you are unable to stop the execution. You are even unable to be on a solid ground to ask for stay of execution, because the National Industrial Court will insist you go back and do those things. And you have no way of asking the Court of Appeal to determine your motion for application for leave in a 1 week or 2 weeks to enable you to come back. What we notice in practice, and most of the time, National Industrial Court at the end of their judgment, we give 30 days within which to comply with the judgment. So that 30 days is not sufficient for you to obtain leave of court and then take the steps you need to take in order to qualify for stay of execution before the National Industrial Court.
Thank you. Okay, there's this comment / question, and I would throw it to both of you. It says, this is from one of the delegates. I personally do not fancy the grant of an order that the judgment sum be paid into an interest yielding account of the court, even when I'm cancelled to the judgment creditor, particularly when the court had granted the post-judgment interest on the judgment sum. My reason for this is that the judgment sum paid into the account of the court are not returned with the interest after the determination of the appeal in favor of the judgment creditor or debtor. But if the money had remained with the judgment debtor, it will be paid with post-judgment interest by the judgment debtor if the appeal is dismissed. I want to know the position of the speaker, why the court does not return the judgment sum with the interest, and how can the interest even be determined? This is because the judgment sum is warehoused in the bank in the name of the court, along with the judgment sum. Bank interest rates are also very minimal. So, okay, can you have a stab at this first before we pass on to Dr. Uche?
Yes, what is clear from my own experience, I've had occasions where money were deposited in court, most of them being at the Federal High Court. What happens clearly is that at the time of depositing that money, you are carried along as the counsel on both sides. You know how much is deposited. You know what interest rate the bank is paying on that amount. The only difficulty you might have is that in some cases where the court have given a specific interest, let's say the court gave you 20% post-judgment interest, and that is less than the interest the bank is paying on the money. That's what we are going to get. But the bank cannot keep the interest that accrued on the money deposited by the court. And that is why the order is very clear. Even the rules of the court say into an interest yielding account. The money cannot be stagnant. So if as of the time the judgment is given, if the principal sum is 10 million, and the court gave judgment for the principal sum, and the interest have accumulated as of the time of the judgment up to 2 million, that means that the judgment debt as of the time is going to be deposited into court will be 12 million. So if we deposit 12 million and interest start to run on it on that day at the rate, at the CBN rate from the bank, that's the interest rate that will accrue on the judgment sum, and that's the only thing you can get at the end of the day. And the courts, and even if I'm a judgment creditor, I think it is fair and better, because when it is with the judgment debtor, even after the appeal, you might have a problem of enforcement. Some companies have gone from when the matter is at the trial court, by the time it gets to the Supreme Court, the company has exists only in name, and you have no means of recovering the money. But if the money is there and you are sure that it is getting some interest, it is safer, it gives you some kind of assurance. And I've had occasions, particularly when the money is not too much, when a client is made to pay the deposit the judgment sum, the client might as well decide that he doesn't want to, the judgment debtor might decide that he doesn't want to pursue the appeal again. It has some kind of psychological effect, except it is somebody who really wants to pursue that appeal, either the money is substantial or on principle. So it is halfway to getting your judgment sum when it is paid into an interest-yielding account. And it ensures that the moment the appeal is dismissed, if it is dismissed, the money comes back to you. And for a judgment debtor, it is also some kind of assurance. Part of the conditions to grant in stay is whether it is possible to recover the money if the appellant succeeds on appeal. There are some money you pay over, by the time you conclude the appeal, it's difficult for you to recover it back when the appeal is successful. So for both parties, if the appellant is successful, he goes to the bank and gets back his money. If the judgment creditor, the respondent on the appeal is dismissed, he gets the money with interest. So I think it works for both ways. And that's why the National Industrial have insisted on doing it, because it ensures that at the end of the day, whoever is successful will get the money.
Thank you very much. Okay. So to answer his question, the interest accruing on that sum in the bank goes to the judgment creditor.
Clearly.
Okay. Thank you very much. Okay. Thank you. I hope that answers the question for the delegate.
If the bank for any reason tries to hold it back, the chief registrar of the court, in whose name the money is paid, will not even try it. As a judgment creditor's lawyer, I have the right to know how much I've accrued in that amount at any point in time. You have the right to receive statements of account. There's no basis for anybody to try to take away the interest that accrued in the money. That's the whole essence of saying it must be paid into an interest-yielding account. Nobody should take away that interest.
Okay, thank you very much. Okay, and thank you very much, Dr. Uche. Do you have any views on this, please?
No, Barrister, I completely align myself with the position OK has taken. Thank you.
Okay. Thank you very much. Now, there's another question here. It goes this way. In order for the judgment creditor to reap the fruit of the judgment sum, can the judgment creditor file for garnishee proceedings at the High Court after judgment has been given at the NICN? Is that a proper route to go?
To enforce the judgment of National Industrial Court at the State High Court?
No, yes, in order for the judgment creditor to reap the fruit of the judgment sum, can the judgment creditor file for garnishee proceedings at the High Court after judgment has been given at the National Industrial Court? Is that a proper route to go?
That would be a very strange process. And I believe the High Court will not have the discretion to enforce that judgment. The National Court has all the power given by the Constitution, directed by the Act, to enforce its own judgments. Why will you approach a different court to enforce its judgments? I've done garnishees. One of the cases I cited here, Echo Corp, is a garnishee proceeding done at the National Industrial Court, and it was faster than the State High Court. It would have been at the State High Court. So I'm wondering, why will I get a judgment at the National Industrial Court that have powers to enforce it, that is, processes are fast and efficient, and I leave it and start to shop for another court to enforce it? National Industrial Court enforces garnishee proceedings all the time, and that's the appropriate court to enforce it.
Okay. Dr. Uche.
Yes, Barrister,
Yes.
I don't have any special view on this matter.
Okay, that's fine. Now, there's another one. It says, regarding appeals as of right from a decision of the National Industrial Court, some judges appear to hold the view that an appeal will only lie as of right where the subject matter of the main suit is on fundamental rights or criminal matters. I'm of the view that irrespective of the subject matter of the main suit, it is a ground of appeal that should be considered to determine if the appeal is as of right. Gentlemen, I would like to get your take on this as well.
This section 243, sub 2 and 3 that we discussed, have already stated clearly. Sub 2 says where it relates to chapter 4 of the Constitution, and chapter 4 of the Constitution deals with fundamental human rights. Say in such cases, the appeal shall lie as of right. Sub 3 states clearly that in every other matter, the appeal shall lie with the leave of the Court of Appeal. And the Iwu and Sky Bank 2017 that we mentioned at the onset gave judicial affirmation to the provisions of those sections and state clearly that in all cases, you must obtain the leave of the Court of Appeal to test the decision of the National Industrial Court, except on matters bordering on chapter 4 of the Constitution. In every other case, you must obtain the leave of the Court of Appeal. And it was part of what lawyers have exploited in trying to avoid the provisions of the 64. You see some lawyers, no matter what the decisions and the issues are in a matter, they will couch the notice, the grounds of appeal to subject the narrow of fair hearing, which falls under chapter 4. So they can file a notice of appeal without first seeking leave, compare and transmit records, so as to stand a chance of persuading the courts to stay proceedings. But you must obtain leave, and from the Court of Appeal too, except if you are dealing with matters that fell under chapter 4 of the Constitution. It is no longer open to debate because the Supreme Court have made that pronouncement in Iwu's case, and unless that position changes tomorrow, but as of now, that's clearly the position of the law.
Okay, thank you very much. There's another one from another delegate.
Sorry, Barrister, say just to.
Oh, yes, Dr. Uche, please. Sorry.
Yeah,
yes, go on.
Just to add to what OK has mentioned.
Yes, please.
That originally the idea stemming from the decree I mentioned previously, decree number 47 of 1992, the idea was really that on interest matters, as much as possible, it should be settled as close as possible to where the matter originated. Interest matters are those matters that relate to bread and butter, pay 10 naira, 20 naira, as the case may be. But if the matter borders on right, chapter 4 of the Constitution, those are the matters where, because of the nature of employment relations, those are matters where the Supreme Court must be the final court to make a pronouncement, because it will affect interpretation of chapter 4. However, the Wood case has settled this, beyond doubt, that irrespective of whether it is an interest matter, opportunity must be given to litigants to again get the opinion of the Supreme Court on those matters. I think that is the position today, and then OK has clearly settled it. But as a practitioner, we honestly wanted that dichotomy, especially in the area of interest matters. Yeah, because irrespective of how competent we say the higher courts are, Court of Appeal and the Supreme Court, the further you go from the parties, the more it becomes difficult to pronounce on those kind of matters, especially interest matters, because those are matters where decisions should be made as close as possible to the facts of the matter. Once you begin to get to higher courts like Supreme Court, those are courts for policy making, and it becomes much difficult. Thank you.
Thank you very much. Thank you very much, Dr. Uche. Now, still on this issue of appeal and the conundrum that we find ourselves. This question says, for a judgment debtor who finds the conditional stay onerous, the usual practice is to seek for a variation order and then further appeal any refusal. Do you consider this to still be a viable option where the National Industrial Court insists on proceeding with enforcement? Okay, over to you. Do you want me to repeat the question?
I got the question.
Okay.
And I say ordinarily it is a viable option from the law as we know it. Because what it will mean now is that the trial court, who is to enforce the judgment, will be confronted with the motion for variation pending at the Court of Appeal. And ordinarily, a trial court confronted with such an application will have to wait for the outcome of that motion at the Court of Appeal. In many cases at the NIC, what I've noticed is that because it is a judgment sum, if it's substantial, the court might stay, on the condition that you deposit. And the person will, of course, file that motion at the Court of Appeal. What happens is a situation where there's also a way for enforcement, like the Echo Cup case I mentioned. The man's motion, though not for variation, it has a motion for stay still pending at the Court of Appeal as of the time the court made the garnishee order absolute. And part of the argument is that even if your application is pending before the Court of Appeal, that the Court of Appeal will look at the court where the thing is coming from and give interpretation to the provisions of the order, like Order 64 in this case. So yes, while I agree that a motion for variation ought ordinarily to stay in the hands of the trial court until it is determined. But I've had experience where a motion is pending at the Court of Appeal and there's a motion, there's a garnishee proceedings, and the court proceeds to make it absolute on the basis that the conditions set out in Order 64 have not been met by the appellant.
Thank you very much. And I'll just dive into the next question. So it says, alternatively, appeals from NIC should be time barred. Maybe a maximum of 6 months to determine at the Court of Appeal and another 6 months at the Supreme Court. Do you agree with this? This is for both of you and reasons. This is for Dr. Uche and Okechukwu.
To me, it's a fantastic suggestion. I think it's part of what we have discussed before, because I think the problem we counter is because of the time. And I believe that a trial court that knows, for example, that this appeal cannot last beyond 1 year, Of course, we know that the Court of Appeal, except in issues, the constitutional issue by way of case stated that goes to the Supreme Court. Court of Appeal is the court of last resort. If the National Industrial Court is aware that a matter is going to be determined at most in 12 months, the court will be more inclined to even stay the execution of that decision or that judgment. But because it is obvious to everybody that appeal is a tedious and lengthy and expensive process, I believe it is the reasoning behind the provisions of the 64 and the way it has been interpreted by the court. So I agree with this contributor that if there is a way which will now require what Dr. has suggested earlier, it has to be a special regime whereby appeals coming from National Industrial Court are treated with dispatch and separately from the regular appeal matters and determined within a specified period of time. The kind of consideration we are giving to election petition matters, something similar could be done for employment-related cases, and they achieve expedited disposal and determination by the appellate courts.
Thank you very much, okay. So, Dr. Uche, I'd like to hear your views on this.
Yeah, thank you very much. I, again, totally agree with the position of our colleague who raised this issue, and then the position taken by OK. I just want to draw attention to, if you recall the ASU case many years ago, when 49 University of Ilori lecturers were involved over a matter of termination. And then the matter continued. And by the time the Supreme Court finally made a pronouncement on whether the university had the power to have terminated the appointment following their participation in a strike that turned out to have been illegal at that time. At the time the pronouncement was being made at the Supreme Court, some of them had died. And it immediately brings to mind what our colleague mentioned, that we must have definite timings to this, given the nature of the subject matter. In the absence of that, you are going to be having the kind of situation where at the end of it, it becomes impossible for the would-be beneficiary to get the benefits of, even if the judgment were to come in his favor. We have seen many of such cases, even in the private sector, where as the matter continued to move on, some of those who would have benefited at the end of the day would have lost their lives in the process. So I completely agree that there must be definite timings so that we give it the kind of priority we have seen attached to election issues. I think it demands that kind of approach. Thank you.
Thank you, gentlemen. I mean, if I may come in here, I think there's some merit in this point in terms of creating timelines, which will also tally with what we have in the Trade Dispute Act, the 14 days and all that. But it is one thing to have this, but in practice, most times, there are always exceptions. And so again, we'll find a way to find a motion to elongate time, and we'll find ourselves going back to the same thing again. I think whilst it's a brilliant idea, I think it's a good idea, I think also the issue that goes to the root of it is funding the judiciary and creating more courts, manning these courts, spending some increasing budget for the judiciary to ensure that if you look at the population of Nigeria and look at the number of people in informal employment and look at the number of cases and the dockets in National Industrial Court, if there were allowed to be appeals on this case, if we take a ratio of 2 out of 5 cases are appealed, we do not have the capacity to deal with those appeals, and the Court of Appeals don't have the capacity, the sheer manpower to deal with this volume of appeals. So even if we include the timelines, if we create a timeline without correspondingly creating more costs or increasing the manpower, then we are back to square one. Because it's one thing to say this must be done within this period, but with all the will in the world, is it realistically practical for the Court of Appeal as it is today, with additional manpower or more costs, to be able to deal with this within this time frame? I mean, this food for thought and something we should also consider in
definitely
having
not.
this conversation. So, okay, we're going to say something.
I said definitely not. That's why when I talk about what is practicable earlier on, I was thinking that the best option of all the available options to expedite matters coming from the National Industrial Court at the Court of Appeal, the most viable option to me is the promotion. After all the time justices of the Court of Appeal retire, new ones are appointed, is to deliberately ensure that a reasonable proportion of judges of National Industrial Court are also among those promoted. They will bring changes in the way and manner employment and industrial relations matters are handled at the Court of Appeal. I gave the example of Justice Amadi, who was promoted from the National Industrial Court. And one of the landmark decisions, I can't remember the case offhand, but it was a decision where for the first time the Court of Appeal agreed with the provision of the National Industrial Court Act that in certain cases, the strict application of the Evidence Act should be introduced. The Court of Appeal agreed with that provision, and it was because Justice Amadi was in that panel and said that Section 84, dealing with documents and requirements for admission of documents and all of that, that some aspect of it could be dispensed with when you are dealing with matters of National Industrial Court, because the National Industrial Court Act actually provided for such deviation. Court of Appeal would not have come to that kind of conclusion. Yeah. It needed a person of Justice Amadi's background from the National Industrial Court to come to that conclusion. So I think that option is more viable, and those stakeholders who are able to bring it about should emphasize more on it. Let a reasonable number of justices of the National Industrial Court get to the Court of Appeal and help to influence decisions at that level.
Thank you very much. Okay, you are one of the stakeholders, and you can also make this happen. So the stakeholders are not different from you or Dr. Uche or myself or every other person on this webinar.
I actually have you and the chairman of the ICLE in mind.
So we are all stakeholders, so we need to do our bit. You know,
yes.
Some legislator, you know, some House of members. I mean, you belong to a network of people. I mean, we all have to take ownership and drive this process of change that we see.
Even NBA as a body, yes, I agree with you completely.
Yeah, thank you. So another question here, and this goes to the. I mean, we can't keep running. We can't have a conversation about National Industrial Court and not talk about jurisdiction. I don't see how that's ever going to happen. It always comes back to jurisdiction either way. So there's this question here that says, where an employee complains that he was not given fair hearing before a disciplinary committee, before his dismissal, and the court reaches a decision against such an employee, can an appeal against such a decision be filed without leave of court?
The fair hearing that the Constitution, the Chapter 4 of the Constitution and fair hearing that is envisaged, it is not denial of fair hearing by the employer. Okay. It will have been denial of fair hearing by the court. The fact that your employer did not give a fair hearing and went to National Industrial Court does not make it a Chapter 4 because the basis of your appeal will not be the decision of your employer to dismiss you. It will be the decision of the court. It would have been different if the court has failed to consider your position or ignore the evidence or failed to hear your evidence in a way and manner that clearly shows that you are deprived of an opportunity to present your case. Otherwise, if we go by that norm, it means that almost all the times when a claimant loses a decision at the National Industrial Court, particularly when it has to do with dismissal or termination of employment, if it goes against the claimant would have been able to file an appeal without leave because he's challenging the way and manner he was dismissed. That's my view.
Great. Dr. Uche, do you have any thought on this?
Well, my thought would be that any matter that touches on Chapter 4 issue, especially the right to be heard, it's something that the court would take very seriously. And here I'm being guided by, if you look at some line of cases, Lasisi Yusuf against Union Bank, cases that came in that direction, where in that case, an individual virtually got to the Supreme Court. An individual challenged the proceedings of a disciplinary committee on ground of lack of fair hearing, that the disciplinary committee erred, and that was the beginning of the matter. And because it was a constitutional issue, all the court treated it in that manner. So whereas I see the point Oke is making, but I think this is a matter where the court will be very sympathetic, because the issue of fair hearing, having been a practitioner, is something that even at that level of disciplinary committee, that you must ensure that nothing may give the impression, even the way you write query, even the constitution of the disciplinary committee in terms of who should be a member, should the individual who issued the query also be sitting? Of course, we have a number of cases in that regard. So I think it is a matter that if you look at decided cases, I think the courts are usually very sympathetic when it comes, and it will be dealt with appropriately.
Thank you, Dr. Uche. I tend to agree with you that in practice, and also one of the errors that just need to point this out for lawyers here who provide advisory services to various organizations. One of the errors that employees fall into is to think that fair hearing means that you must be present and allowed to speak at a disciplinary hearing or at a formally organized disciplinary hearing. But in a long line of cases, National Industrial Court has also held that by giving an opportunity to respond to a query is also an opportunity to speak, because you explain within 48 hours why disciplinary action should not be taken against you, and the person doesn't respond, and then goes on to say, oh, I was not given fair hearing. National Industrial Court has turned around to say, no, you were asked for your view and your opinion on this, and you did not respond. So you were actually given an opportunity to state your case. And so and I hear you, Dr. Uche, in practice, we must do better in advising our clients as to the process to follow, who issues the query, the time frame for responding to the query, what are your rights in terms of this, in a proper hearing, are you allowed to come with a colleague? What are the rights of the colleague who's coming? Is he allowed to plead your case? Is just to provide support? All these things must be part of the process explained to employees alike when it comes to a disciplinary hearing or an investigative hearing or whatever it is termed. But that opportunity has to be created, and it has to be explained better, and people need to understand what their rights are. And I do agree with you on that, that in practice we need to do better as well. Okay, I think we're gradually winding down now. There's this other question which says, it goes thus. Please, which category of labor industrial cases can be appealed to the Supreme Court from the Court of Appeal? Okay, starting with you.
Come again, in which category of?
Which category of labor industrial cases can be appealed to the Supreme Court from the Court of Appeal?
I mentioned it earlier. There's only one area, and that is a constitutional question. If you check the Woods case, for example, the Woods case is a classical example. Classical example of a matter that came from National Industrial Court to the Supreme Court, because it came by way of case stated, where you state a question, a jurisdictional question for the termination of the Court of Appeal. It can go from Court of Appeal to the Supreme Court. In every other cases, the appeal terminates at the Court of Appeal.
What about criminal cases?
No, criminal, we are talking civil. Sorry, I'm talking general about civil matters. Our presentation doesn't have to do with the civil procedural rules. I'm talking about in civil cases.
Okay, because the question was really, please, which categories of labor industrial cases can be appealed to the Supreme Court? So I needed you to make that clarification as well, to make that, draw that distinction as well.
Apart from the case stated options I've mentioned, criminal matters, of course. And if you look at the section 243, you will see that clearly when you make that exception about leave, it was talking about when the National Industrial Court sits in a civil jurisdiction, not criminal.
Okay.
So criminal is not limited by that same provision.
Thank you. I mean, it's always best that we mention this and drill it down so that people don't make those mistakes. It's very easy to fall into those errors, but it's important that we also make this point to everybody, because the challenge we have also, we have people who are just fresh out of law school or who are in law school still listening to this, and some of these things are not taught in the law school. So it's best we just point them out so that people also know about these things. So I think that is all the questions here. So just some final thoughts from you, okay, and from you, Dr. Uche.
Yeah.
Final thoughts, please, on this issue of appeal and the way forward.
Okay, I'll go first. Let me defer to Doctor to conclude.
Okay.
Okay, so my final thought is that what I've done is not necessarily to provide solutions, but to raise the issues and architect our minds. But I think in the course of answering the questions, we've been able to identify the things that might help in resolving these issues. I think that the National Industrial Court could be more liberal. I've demonstrated from 2 decisions where they were liberal. And I think that what happens now is that maybe the judges, depending on the facts of a particular case, decide whether they have to be as liberal as Justice Abokoba was in one of the cases I cited, where my lord treated a pending motion for leave to appeal as a notice of appeal, and on that basis granted a stay. In other cases, it is very clear that they will insist, like the example I gave of Justice Essen, where he said it is, you can't even imagine it. You can't approach the NIC for stay when all you have is a motion for leave to appeal. So I think that there should be some kind of flexibility, while the National Industrial Court will continue to insist on protecting the employees who are vulnerable, and ensure that stay of execution is not granted as a matter of course, and that the court does not make it a habit to deprive successful litigants of the fruits of their judgment. But it should also consider other factors. There are strenuous factors that have been established before now by the Supreme Court for grant of stay of execution, and even other courts do not grant stay of execution as a matter of course. Why it should be a strenuous exercise, but I don't think that the strict application of Order 64 will serve the best interest of justice.
Thank you, Dr. K. Thank you, K. Well, soon to be a doctor, but now the current Dr. Uche, please, that we know of. Over to you, sir.
All right, thank you very much. And I want to thank Uche again for providing these additional insights to guide all of us when we come to practice. I want to also mention here that our current industrial courts cannot, by any standard, to be said to be old. If you look at the history, beginning from the National Industrial Court Act to the third alteration, 2010-11, we see that the court is growing. And therefore, it is the duty of all of us as practitioners to, as much as possible, provide information. Each time I listen to the president of the Industrial Court, I'm always very, very happy in the sense that he's open to hear global best practices. On one occasion, he mentioned the short tenure he had at the International Labour Organization, where he served as a member of what we call Committee of Experts in enforcement of conventions and recommendations. And therefore, he is fully aware of the growing jurisprudence in the area of employment laws, industrial relations. And therefore, as practitioners, we must continue to support the industrial court so that in years to come, the court will have gained a considerable reputation, because it is that reputation which you find in some jurisdictions. And I mentioned the industrial court in Kenya, where parties, based on the reputation, we no longer find it attractive to begin to appeal decisions. Not because the Constitution says you can or you cannot, but because over time, based on their reputation, and even when you appeal, the Court of Appeal or any other court will first say, for industrial court to have taken this decision, there must have been merit. And if that happens on a couple of occasions, parties on their own will begin to refrain or begin to exercise greater caution when they go on appeal. And I find that that has been the case in jurisdictions that have had the opportunity to participate in their industrial law process. Sometimes it comes under what is called judicial globalization, that people learn from other jurisdictions in terms of how industrial courts have been able to build a very solid reputation. And it is that reputation that will restrain parties from unnecessarily going to test their judgment. I'm looking forward to that situation. And it is for all of us as practitioners to give support to our industrial courts so that they can grow in this respect. Thank you very much.
Thank you. Thank you very much, Dr. Uche. I'm very grateful that you've always found time in this past couple of days to join us every day. We're grateful. Let me just make the point again that all the slides will be made available to all attendees by email. It should be, videos will be up on YouTube in a very short while. We'll confirm what date or time that will be done. But let me also use this opportunity to invite everyone, if you can. We still have other robust conversation. The last of the series comes up tomorrow, same time. We'll be grateful. We're happy to have you and then have your questions and have a conversation again. But as stakeholders in this quest to develop the National Industrial Court, there is a bar and bench forum where you can sit down and have a conversation, ask all the judges of National Industrial Court questions during the course of their legal week, which usually be in October. We will circulate the invite and let you have the notices of that, and you can join. It'll be another opportunity for us to help drive some of these changes we are pushing for, and speak to the National Industrial Court judges themselves and say, these are our thoughts. And I think from today's session, we've come up with some very practical solutions in terms of creating the time frames for appeals, getting more appeal court National Industrial Court judges into the Court of Appeal system. Haven't seen the influence that Dr. Amadi has made over there, and creating more courts, specialized appeal courts as well. And these are all practical solutions that together, if they come together nicely, they could help improve the employment and industrial relations jurisprudence and practice space. So on that note, I would like to say thank you to everyone who has taken time to be here today and stayed all through. And I always say thank you to the backroom staff of the NBA ICLA for the fantastic job you guys do all the time, Sarah and team. Thank you, Awole. Thank you very much. And the DG and chairman of the board, Mr. Tabile Rojikwe. Thank you all for the fantastic initiative. We look forward to tomorrow when we conclude. And so let's call it a day and see you all tomorrow. Have a blessed and great day. See you guys tomorrow then. Bye-bye.